Hello and welcome to the Legal Edition. I'm your host, Attorney Mary Kay Elloian. Our topic today, Posse Comitatus and the Insurrection Act. Does the president get to call all the shots? Our guest today is retired Brigadier General Michael C.H. McDaniel. He served at the Department of Defense as Deputy Assistant Secretary for Homeland Defense Strategy on Force Planning and Mission Assurance. He also served under President Obama, drafting policy for the Council of Governors on state National Guards, defining their role in homeland defense, civil support, synchronization, and integration of state and federal military activities in the U.S. He is Associate Dean Emeritus of Cooley Law School, Homeland Security Law Programs. Let's welcome retired Brigadier General McDaniel. Welcome, General McDaniel.
Thank you. Thank you for this opportunity, Mary Kay.
Now, you have written extensively on some of these topics, and you've been involved on the national level. Tell us, what is the Posse Comitatus Act of 1878, and what does it entail?
Right. The Posse Comitatus Act is a great starting point for us today because it is a recognition that continues from after the Civil War until this day, but really throughout our history, from the very beginning, with the caution that General George and President George Washington used after the Whiskey Rebellion. But this is the codification of the Posse Comitatus Act after the Civil War, during the Reconstruction era. It was sort of a corrupt bargain at that point between Southern Democrats who were sick of Reconstruction and the occupation by military troops, and Rutherford B. Hayes getting the necessary electoral votes to be declared president over the Democratic candidate Sam Tilden. But what it did, getting to the point, what it did is it specifically says that the military cannot be used domestically unless it's expressly authorized, and I emphasize that intentionally, expressly authorized by the Constitution or other statute. And if the military is used and it is not so authorized, then they call it a 2-year misdemeanor and or a fine. So it's a criminal penalty for the use of the military domestically in the United States without express authorization, which, let me just add right at the beginning, and we'll talk about it more, I'm sure, but there is no express authorization in the Constitution for the president as commander-in-chief to use military troops in the United States. It's not expressly authorized in the Constitution. It is by other statute, but it's not in the Constitution.
Now, how does that square with the Insurrection Act of 1807?
Sure. The Insurrection Act goes back to what I referred to with the Whiskey Rebellion with President Washington. And it's really a codification of different sections over a period of time. And those sections sort of laid out when Congress says you can use the military. So starting with the Constitution, as always, at Article 4, Section 4 of the Constitution, it says that the upon application by the legislature or by the executive of a state, if the legislature be not in session, then the president may use troops to quell domestic violence. So we also have the calling forth of the state militias clause, calling forth of the militias clause under Article 1, the powers of Congress. So the Insurrection Act has to be read consistent with those two provisions of the Constitution, that there is, if there's domestic violence, then the governor or the legislature has to ask for the federal assistance in the form of military troops, or that you have already, and then the Congress acts under the calling forth of the militia clause. So when we look at the Insurrection Act, we have three different sections there. But with the first section of the Insurrection Act, just as it states in Article 4, Section 4, if requested by the governor or the legislature of a state, then the president may send troops into that state to assist with quelling unrest, domestic violence, etc. The second provision is the one that's the most contentious because it suggests that on occasion that the president can send in military troops, even if not um, called by the governor to do so. The third one, and the one I always find of most interest, Section 253, says that the president can call in troops without a request from the governor if portions of the state population are having their constitutional or civil rights being violated with violence, and that the state refuses to act or has the inability to act. There's also a portion there that suggests if the state is involved in those actions, then the federal government could then act with military troops. And that has not been tested, but that language concerns a number of law professors and commentators.
Mhm. Well, as a former law professor yourself, I know you're well versed in all of this, plus your military service and your assistance with the White House Executive Office with regards to some of these issues. Um, how do you read 10 USC section 12406? That is the one that has pretty much allowed the National Guard units from any state to be federalized as per the appeals court in the Ninth Circuit. And they did so recently when LA was under protest, I should say. Um, and the Ninth Circuit overturned the ruling by the district court judge that said the president couldn't call them out, to say that the president had a right to call them out to protect, I guess it's circumscribed, protect federal buildings and federal employees, which would include ICE personnel. What is your feeling about that ruling?
Right. So I have a lot of concerns with that ruling. First, as I read Section 12406, the purpose of that was to provide this mechanism by which, consistent with the Constitution, National Guard troops could be called into federal service. And it specifically talked about those requests passed through the governor. And I read that to be much more than just a ministerial act by the governor, that it required some executive discretion on the part of the governor to be consistent with Article 4, Section 4 of the U.S. Constitution. Secondly, the idea that you can have this definition of a rebellion, I think, should be considered, should be everybody who tries to interpret that should be very circumspect. A rebellion, of course, means the use of our own citizenry, as opposed to an invasion, the use of our own citizenry against the government. And I think that definition, where you're trying to overthrow or to take serious action against the government, should be read that way, as opposed to read to be any action where there is violence against federal property or even federal individuals. Because that goes to the third idea. The White House in its executive order that started all this back in June 7th, or really it was sort of a memo from the president on June 7th, said that they were acting under 12406 and this idea of the protective powers. So it's not really 12406. As I said, that's a mechanism to bring the National Guard in certain circumstances. The protective powers of the president is sort of this implicit power that is derived, I should say, from the take care clause, take care that the laws be faithfully executed. So there is always, and that was absolutely stated to be such by Attorney General Bill Barr during Trump 1, when we had protests in Washington, D.C. against racism back in that period of time. And that's what they stated they were doing based upon an Office of Legal Counsel memo, goes back to 1971. It's always been the position of DOJ and White House that there's this implicit protective power of the president. But that is an implicit power, and what we need is a determination as to whether or not the Posse Comitatus Act, which precisely says that it has to be expressly stated by constitution or statute that you can use troops for law enforcement purposes in a domestic setting. So the idea here of using 12406, I think, is insufficient. Even if it does talk about rebellion, I don't think that this fits the definition under Merriam-Webster or anybody else of a rebellion. And thirdly, I think that you have to look at this in the context of the pre-existing Posse Comitatus Act, which I believe this further statute 12406 was intended to assist with. They have to be read together, and the idea that you're relying on protective powers that are implicit in the power of the executive branch, I think, is insufficient, and it should be insufficient because when you look at the scheme of the Constitution, we certainly cede to the president full, as some cases say, plenary power over foreign policy and foreign affairs. Certainly, that is not true domestically, where we had a limited provision of states' powers to this new federal government in those areas. So, unless it's specifically stated, I don't think that it applies, and I think the Ninth Circuit's wrong in this case.
Mhm. Yeah, the Ninth Circuit was pretty much hanging their hat on the third prong of USC 12406, which not only says suppress rebellion, but or execute the laws. And they felt that ICE couldn't execute their raids on these people. And because there was some damage to federal buildings, that they could invoke that provision. What do you still feel the same way that that was overreach?
I do, and I apologize if I conflated parts 2 and 3 of 12406. Yes, the third one talks about the inability for regular law enforcement to execute the laws of the United States. Um, first of all, that's factually incorrect from what we saw in LA. Certainly, both LAPD and LA County acted very aggressively against the protesters.
Mhm.
And certainly, I don't think that um, there was there were any issues that were of such scale that they needed federal forces. But that's factual based.
Mhm.
And I do believe that the courts have the authority. I don't think, which is the more important issue, and that is, I don't think that we can just say that the president has unilateral authority to make these determinations. Again, when it's involving A, in the interpretation of the Constitution, and B, the rights of both citizens and other persons residing within the state of California or anywhere in the United States. So I do believe that the courts can look at this. There's this almost a suggestion in the opinion that this is for the president only, which I don't believe that it is. And secondly, I think that to the extent that 12406 Section 3 is consistent with the Posse Comitatus Act and inconsistent with the provisions of the Constitution that I'm relying on, that the court is still wrong on that. The
Mhm.
Ninth Circuit is still wrong on that.
Right. I'm wondering if this will go all the way to the U.S. Supreme Court. I guess we'll have to wait and see.
Yeah, and I imagine it will, Mary Kay. I imagine it will.
Mhm.
Uh, I hope that they consider because remember the Department of Justice first argument before District Judge Breyer was sort of this non-justiciability issue, which is why I keep saying that there's a difference between interpreting the concept of what is war and when it's declared, and the concept of a rebellion, which I think is much clearer. Why that's important, and it has to be justiciable to determine the definition of rebellion as used several times in these statutes. So yes, if we say that rebellion is non-justiciable, as the DOJ on behalf of the Trump administration argues, and we say that the president is absolutely immune from decisions made during while acting within the course of his authority, we've just granted him unbridled authority on matters of the use of troops within the United States, and that is a big, large step towards an autocracy within the United States that I don't believe is necessary or wanted by the vast majority of the people in this country.
Yeah, one of the claims by California was that he was acting ultra vires, in other words, beyond the scope of what was required or his position allows. But again, The Ninth Circuit struck that down.
Correct.
Well, let's pivot a little bit to the Marines. Now they've called out the Marines. What statute, if any, would allow any of this to occur on U.S. soil?
There isn't any. Frankly, if it were to happen, it would have to be under the Insurrection Act. As I said, I don't believe the Insurrection Act is constitutional, absent the agreement and this express request of a governor or state legislature. So I don't think there is any authority by which they can be used. The White House and previous presidents, I must say, have long been of the opinion, and the Office of Legal Counsel at DOJ has stated that troops may be used under the protective powers to protect federal buildings and federal personnel. If that be true, and it has never been stated specifically by a court, that be true. I know there's old cases like In re Nagel that sort of talk about that, but they're not precisely on point. But if that be true, it still does not mean that they have the authority to engage in search, seizure, or arrest authorities. It only means that they can, in my mind, be a static presence in terms of protecting the building. The difference, if you will, between a security guard and a certified law enforcement officer.
Do you want to talk anything more about the Marines or the Marine use in California?
To say this. If it sounds like as a former brigadier general in the National Guard and as a Department of Defense official that I am reluctant to use military troops, you're absolutely correct. The not just the authority of the military itself, but its standing and credibility in the U.S. community, the civilian community, is due to the fact that we are and should be considered as a tool of last resort. We are sent in when no other means can possibly be implemented, and we stand by our oath, which you take to the Constitution of the United States, and if you're in the National Guard, to the Constitution of the state of Michigan for me, or the state of California for California National Guards. And that means it's to the Constitution, it's to the concept of the rule of law, it's not to the commander in chief. Certainly, if you disparage the commander in chief, you can be subject to Uniform Code of Military Justice. Certainly, that makes sense. It's all part of military respect and duty. But our overall mission is on behalf of the people who enacted and continue to amend as necessary the Constitution of the United States when necessary, not to any individual. So if we're to act in a way that is precipitous, if we're to act in a way that is not in the minds of the majority of the people to be considered that last resort, then we become something less than the U.S. military. We become just an instrument or a tool of whoever is currently either the governor or the president. So you have to look at this with resolve but also with reluctance before the National Guard or other military troops should be used.
Mm-hmm. Now, let's switch a little bit to the international arena. I want to talk a bit about the War Powers Resolution or Act. Can you speak to that specifically?
Sure. So after some excursions by then President Richard Nixon outside of Vietnam into neighboring countries that provided what I think a well-founded fear of a expansion of military in Southeast Asia, Congress passed the War Powers Resolution, which became the War Powers Act. It has two main parts to it. First and most importantly to me is the idea of the notification clause therein, which states that the president as commander in chief has to notify the leaders of Congress prior to action being taken, or or within 24 hours, and it can be 48 hours depending upon the exigencies of the event. This is only in those cases, remember, and I should have said as a predicate, when there is insufficient time in the mind of the president as commander in chief to seek a declaration of war or to seek authorization for the use of force from Congress itself. Only in those circumstances may the president act without receiving approval of Congress, because Congress has the authority under the Constitution to declare war and that sets the terms for the use of the military. There's a second provision which says that if Congress does not ratify the actions, if Congress does not ratify the actions of the president within 30 days, or it can be extended to 60 days, then troops have to come home.
Mm-hmm.
Almost every president, other than President Trump last week, has been consistent with, has followed that first provision about providing notification to Congress. I think just about every president has ignored the second provision about when to bring the troops home. That part doesn't bother me as much because Congress has other authorities available at that point in time, such as voting to limit the funds or how military funds can be used or allocated. But as to that first portion, if you think back to the events after 9/11, which, you could make an argument that was an invasion or
Absolutely could make that argument.
yeah,
Yes, definitely.
but George W. Bush went to Congress and received two authorizations for the use of military force, one against Iraq and one against terrorist groups, Al Qaeda and other similar groups. And that definition of Al Qaeda and similar groups was somewhat hazy and has been used by every subsequent president, I believe, to continue our so-called war on terrorism overseas, where we're using military troops. But in that case, where we had a very clear breach of peace and harmony of the
Exigent
United States.
circumstances, I would say. That was an
Yes,
exigent circumstance.
absolutely. But he
Emergency.
still went. He went, and because it was very clear that this was going to devolve into an armed conflict, and which it did. That he needed to get this permission. So he had the ability to do so, and he did so very quickly. As I recall, he did so, if I
Mm-hmm.
remember correctly, he did so within 48 hours of the attack itself. So certainly this can be done and should be done
Yeah.
for
Compare that though to what just happened recently with Trump dropping bombs in Iran on supposed uh, area that had nuclear proliferation items and mechanisms. That was not an exigent circumstance. They knew about that for some time. In your opinion, should he have gone to Congress?
uh, absolutely. I mean, there's two issues here now. Under international law, to use force in another nation or against another nation state, a couple of circumstances has to be present, and the most importantly, you're acting self-defense of your nation or self-defense of an ally. To do that, though, there has to act in self-defense. There has to be an immediate threat. Goes all the way back, I think, to the War of 1812, but it goes all the way back. The United States has said we will act first. We don't have to wait, as I think Daniel Webster said, we don't have to wait till we get punched in the nose to punch the other person. So we will, and that was obviously, involving United Kingdom at that point in time. So we will act to take steps first, but you have to be able to demonstrate the immediacy of the need for action. And there is a famous exchange of letters between Daniel Webster, Secretary of State, and the minister in England on that very subject as to whether or not that was imminent. We don't have that here. There was no demonstration that there was a imminent attack or an immediate threat to the United States or to Israel. And so I think President Trump failed in two regards. First, I think he violated international law by not stating what the immediate threat to the U.S. or to Israel was, and demonstrating that. And then, secondly, of course, he violated the War Powers Act by not providing notice to Congress. Now, there was almost, when this first happened last week, there was a little flavor of some officials saying, "Well, this was a military ruse. We were sending our B-2 bombers in two different directions. We were sending them to Guam, and that was a ruse for the ones that were going straight across the Atlantic for Israel." And absolutely, a military ruse is absolutely consistent with if it's done legally, other matters. But military ruse is absolutely consistent with international law. But under the War Powers Act, he would still have to notify the leadership in Congress, the four leaders in Congress. That wasn't done. And that has always been done in previous foreign excursions where presidents, as commanders in chief, believe it necessary to act in self-defense and to act immediately to protect the United States.
Mhm. Could it be that President Trump doesn't trust his own cabinet to contain this information? I mean, there's been a number of leaks from a lot of places in this administration. So could that potentially be the reason he didn't go to Congress, in your mind?
Well, I don't want to speculate on whether he trusts his cabinet members, but I will speculate on another part of this. Uh, if in fact you are using outside apps, such as the Signal app, certain data can be garnered by the other users or by third parties when you're using an open app like that. Plus, there have been reports that the Secretary of Defense has used a personal phone. Having served in the Pentagon for 2 years, I was aghast to learn that you would never have be using a personal phone in the Pentagon. Because the data itself can be, in terms of, can be determined. So it may be that somebody and his national security advisor, Rubio, or somebody may have said to him, "We got to be careful on how this information is spread." But I don't know that. But I
Yeah.
will point out that there is a possibility for a couple of breaches there, and hopefully those potential breaches were being considered and being remedied in some way.
So I guess taking all these laws, both those domestically and internationally, what we have seen so far, I mean, we're only into this administration, what, 6 months? Where do you see this going?
I am very concerned, obviously, that we are moving from the idea of a commander in chief who understands the need to rely upon Congress um, and its guidance and is subject to the courts. I am worried that those checks are being substantially weakened to the part that if they are ignored further, that we'll have a true constitutional crisis here. Um, you can argue whether or not we're in a constitutional crisis already. But certainly there has been a weakening of those checks, which are necessary to have on a commander in chief in a democracy and under the terms of our Constitution. So I would hope that we see two things happening. One, a realization among members of the Supreme Court that the idea of a unitary executive, as that concept is bandied about, is inconsistent with the Constitution. And secondly, that Congress will come to the realization that it has an oversight power that it should be exercising. And if the current Congress is unable to do that, that the next Congress, elected in 26 to take office in 27, will realize that.
I do hope so. I hope there will be some resolutions to these acts that have really put in question the rule of law, whether this president is following the law, and hopefully it will get our Congress and the Supreme Court to align to bring justice to America and our partners around the world. Thank you so much today for this hearty discussion. And I look forward to continuing it at a later time. Thank you so much.
Thank you, Mary Kay. It's been a pleasure.
I want to thank our guest for sharing his insights and opinions on the rule of law as it relates to national security and the National Guard. I also want to thank you, our viewers, for tuning in. For more information on today's topic and our guest, visit us online at thelegaledition.com. As always, this information is for general educational purposes only. It is not to be construed as legal advice. So please consult a qualified practitioner as to your own legal or policy needs. And don't forget, you can download our podcasts wherever you get them and subscribe on Substack, YouTube, Instagram, and now Blue Sky.